Okay, we'll go ahead and get started. My name is Chris Pelkey. I'm a labor and employment lawyer with McInnes Cooper in their Fredericton office. And with me on the line, I have.
Hi, folks. I'm Alex Warshick. I am a fifth-year associate in our labor and employment practice here in Halifax. I'm a late substitution. Kirsten, who you may have seen in the advertising materials for this program, was called away on an urgent matter in court. That sometimes comes up in this line of work. So I am the last-minute sub-in. Hopefully, I can add something of value to the presentation today. Very nice to have you all on the line, and thanks for joining us.
Yeah, perfect. Thanks, Alex. So today, kind of what we wanted to go over is a topic that I think is kind of emerging in the field of labor and employment law, and that's this idea that if you have kind of one single employee dismissal, especially when you're considering a dismissal in the context of a harassment complaint, you can actually end up in a situation where you have several different claims against the employer in several different forums with different rules in each one, different timelines, different standards of proof. And like I said, this is an emerging issue that employers are starting to run into. And we just kind of wanted to use this time today to give you an overview of kind of what you can expect a little more of going forward in this space. So Alex, I don't know, do you want to just start off here with?
Sure. So one of the interesting things about the topic that we're covering today is that this is all fairly recent law. We're going to talk about some sort of heavy-hitting cases that have come out in the last 3 years, one from the Supreme Court of Canada, and then one from the Court of Appeal here in Nova Scotia, and one from the Court of Appeal in New Brunswick, I believe. But these are all recent decisions clarifying sort of the roles of certain statutory decision makers and the courts and grievance arbitrators. So it's a messy, tangled web. We're going to talk about sort of the ability of employees to make claims under multiple pieces of legislation and before multiple decision makers. And we're going to give you some examples, some sort of real world or sort of hypothetical examples of an employee who has a claim who then decides to pursue it in multiple ways, and how tricky that can be for an employer in trying to respond to those. What immediately comes to mind is when you have claims that are competing under multiple statutes before multiple decision makers, is that then you can be faced with arguing multiple legal tests. So what one decision maker uses as their test to decide an issue may differ slightly or more significantly from another decision maker. Generally speaking, I think the law is often very similar across these bodies. So whether you're before the Human Rights Commission dealing with an accommodation issue, or you're before a grievance arbitrator dealing with an accommodation issue, the general case law they're going to refer to will be very similar, if not the same. But there are going to be instances where decision makers have their own policies and procedures that will differ. There's also differing burdens, so what you need to prove may change depending on what proceeding you're in or who you're before in terms of a decision maker. Things like the order of calling evidence, who goes first, may change. So, for example, in a grievance arbitration over an unjust dismissal or a wrongful dismissal, it would generally be the employer that's going first, which is different than in a civil claim, where the employee is going first and proving that they've been wrongfully dismissed, and then the employer is defending. So that's very different when you're before, for example, the Canada Industrial Relations Board, if you're federally regulated, or a grievance arbitrator, and you as the employer are trying to justify a termination for cause. One of the other ones, and one of the other points that's really hard to wrap your head around, is that these bodies all have different remedial ability. So some of these statutory decision makers, for example, the Human Rights Commission or labor boards or labor standards tribunals, they have quite broad remedial powers, in some cases I would say broader than the courts, and they can order things like, for example, reinstatement in non-unionized workplaces. So here in Nova Scotia, we have a section in our Labor Standards Code, Section 71, that limits the right of employers to terminate an employee's employment if they have more than 10 years of service. And the remedy for a breach of that section is generally reinstatement to employment. So it's almost a seniority right that you would see under a collective agreement that's been enshrined in the Labor Standards Code. And there's really only two very narrow exceptions to that rule. Well, there's three. One, you have cause, but if you don't have cause, then it's really got to be a discharge for shortage of work or elimination of position, and whether or not that's been done in good faith will come into question. The other thing to keep in mind with some of these statutory claims, so for example, you have an employee who's pursuing you for wrongful dismissal, and they have launched, let's say, a three-pronged attack. So they've made a claim of discrimination in the Human Rights Commission or at the Human Rights Board of Inquiry. They have sought their statutory entitlement to notice at the Labor Standards Tribunal, and they're seeking common law reasonable notice in the court. One of the things to keep in mind is that some of these claims are much cheaper for the plaintiff to pursue. Some of them have no cost at all. For example, a human rights claim is a very low cost proceeding for a claimant. The claimant goes to the Human Rights Commission. The Human Rights Commission helps them along the way to draft the complaint, investigate the complaint, make a decision. And while it doesn't really advocate on their behalf, it does help them through the process. And that's similar in, for example, labor standards complaints as well. So there's a low barrier to entry on a lot of these complaints for an employee, which makes pursuing multiple proceedings much easier for the employee, whereas the employer then is now defending 2 or 3 different kinds of complaints in different bodies, and generally speaking, incurring legal fees, the cost of time to defend these complaints and claims. So you can see how this can be, it can be quite onerous on the employer in responding to all of these complaints. In terms of what these proceedings or claims might be, so employment standards legislation, that's the Labor Standards Code here in Nova Scotia. Employment standards legislation covers things like wages, vacation, hours of work and overtime, leaves of absence, also has protections against retaliation, sometimes called whistleblower protections. So you may see claims that come out in that forum. A great example or an easy example would be the employee is suing you civilly for wrongful dismissal, but they also say that you've shorted them on their vacation payout at the end of termination. So rather than including that in their civil claim, which might take years to proceed, they go to the Labor Standards Tribunal and file a complaint for vacation pay because they can get that much quicker. And then strategically, as the employer, you've got to be aware that that employee, having got their vacation pay, now has money to pay a lawyer to continue their civil claim. So, again, it can be quite complicated. It can change your strategy quite a bit on these claims. Other types of claims, occupational health and safety. So this would be workplace harassment and violence, reprisals, unsafe work condition complaints that might have led to or contributed to, for example, a constructive dismissal claim. Pension benefits, human rights, often you see attached to or sort of corresponding with a wrongful dismissal claim, claims of discrimination. So, the employee can either pursue that in their civil claim, or they can carve that out and pursue it in a sort of low-cost fashion at the Human Rights Commission or Board of Inquiry. Workers' compensation, labor relations, and then, of course, common law, which is sort of the big ticket item typically for wrongful dismissals.
Thanks, Alex. So one of the things that we kind of wanted to do is just provide everyone who's attending this webinar with kind of an example of how something like this can play out. And kind of one of the biggest places where we're seeing this kind of from our side of the table happening is in the context of employees who bring harassment complaints and then are terminated shortly after bringing those harassment complaints. And so kind of one of the things that I know I'm seeing a lot kind of in my line of work and with the cases I'm dealing with is that you'll have, anytime there's a complaint of you know, a toxic work environment, anytime there's a complaint of harassment in the workplace, it's usually gotten to the point where things are broken down between multiple parties and multiple people kind of have competing claims against each other. So, you know, you may be subject to workplace harassment, but you may also be a person who's kind of engaging in harassment yourself. And so employers do find themselves in tricky situations in these cases where, you know, there are multiple complaints that are filed and they make the decision to terminate an employee who has actually filed a complaint and who has a complaint ongoing. And so we kind of want to go through that example because it does engage kind of all the different considerations that Alex talked about, and it engages multiple statutory proceedings and of course the court process. So in this case, we've got Pat, who's a non-unionized employee who brings a complaint to their manager that their supervisor has harassed them. You see this a lot. Lou, the manager, is golf buddies with the supervisor, and Lou doesn't investigate the complaint and just dismisses it as being unfounded. 3 weeks later, the employee gets a termination letter saying they've been terminated without cause, and the letter cites performance reasons. The employees only paid their statutory minimums and asked to sign a release. So we just kind of want to walk through the different claims that can come up, and many of you will be familiar with these, and I think the big takeaway from this is that in one circumstance, as we've said before, you could be faced with multiple complaints, which will have a variety of different implications. So the first kind of complaint, and this is kind of as Alex said, the big ticket item that all employers see in cases of termination is a wrongful dismissal claim that's brought in a court of competent jurisdiction, Superior Court. In these cases, the employee alleges that they've been wrongfully dismissed, they haven't been provided with reasonable notice of termination, and they'll often claim damages for reasonable notice, or they'll always claim damages for reasonable notice. What you also see in these cases, especially in the context of harassment, is Wallace damages, which are now kind of more commonly referred to as aggravated damages, and punitive damages. And again, they're very similar, and there's kind of minor distinctions, but when you're dealing with harassment, you'll usually see both. So aggravated damages are usually used to deal with bad faith conduct. So in our example, the employee was terminated by a manager who was golf buddies with their supervisor, who was the subject of the complaint, and without an investigation. And so on its face, it looks like there may have been some bad faith conduct there. And, you know, the employer in this case would have to be very careful or else they'll find themselves kind of slapped with aggravated damages. Punitive damages kind of go beyond that, and like their name suggests, are intended to punish an employer for particularly egregious behavior. So it's a very high threshold, and it usually requires kind of very heavy-handed, bad faith and behavior that, as the court says, kind of offends the court's sense of consciousness. So it's got to be quite bad. In cases of harassment, you can see punitive damages, especially where the employee is able to kind of convince the court that yes, they were subject to harassment, and yes, this contributed to or was in some way related to their dismissal. So this is kind of the big one. Most people are familiar with it. And again, like I say, your big three that you're going to want to watch out for here are reasonable notice claims, Wallace, and punitive damages.
Just on, I might just jump in for a second. Just on Wallace damages, or sometimes they're called bad faith damages. In Nova Scotia, there was a Court of Appeal decision last June 2023. Hiltz and Elmsdale Landscaping, and I think you'll find an article about it on our website actually. Essentially, the courts are more willing, I would say, to award these damages on a lower sort of evidentiary threshold. Used to be that these damages were almost always claimed, but not always received if you got to trial. Generally speaking, the employee had to bring forward some kind of medical evidence that they'd suffered depression or anxiety, or something to that extent, that the termination had had an effect on their personal health and well-being, or on their reputation, and generally had to bring some kind of substantial evidence of this forward. What was interesting in the Hiltz and Elmsdale landscaping case is that the evidence that the employee used of the effect of the termination on them was really just sort of their own personal statement that they'd been significantly affected by the termination, that they were feeling depressed and anxious about getting back in the workplace. And then they also filed an affidavit from their wife that said, he hasn't been the same at home, etc. So it didn't rise to the level of expert medical evidence that this person had been significantly affected medically by the termination and by the way that they had been terminated. It was really just sort of the employee and the employee's family saying, this has really affected us. And so that's a much lower standard than what the courts were previously kind of expecting in proving these damages. And the award in that case was for $15,000 in these aggravated damages. So that's above and beyond what the employee got in reasonable notice. So these can be significant claims, and you almost always see these claimed now in the actual lawsuit and in the demand letters you receive.
And I think to kind of add from that, just to give you an idea of kind of how far these types of damages can go and kind of the extent that you can find yourself liable. In New Brunswick, many of you are probably familiar with the Dornan decision. It was a public service labor relations decision, but the principles kind of apply across the board. And that was a case involving the Horizon CEO, who was kind of terminated unceremoniously following the death of a patient at a hospital that was kind of under his mandate. And the termination was done kind of right before a scheduled public media interview. And so in that case, the arbitrator, because it was under the Public Service Labor Relations Act, kind of considered the situation holistically, along with, as Alex said, these statements about how it affected Mr. Dornan, and kind of inferred how something like that, a public termination, it was shortly after a death, and how a member of the public would reasonably connect the two, considered that behavior to be quite egregious, and actually awarded $200,000 in aggravated and punitive damages. So I think to Alex's point, one, the threshold's getting lower, and two, the awards are getting bigger. So that's quite a large award, and as Alex said, that's on top of notice of termination.
Yeah, the big takeaway is that when you are dismissing an employee, everything's got to be above board. Do things in their proper way. Meet with the employee. Be very civil. Avoid doing a termination that's going to be sort of public. Be very careful around the messaging around terminations and what's shared with other employees and with your clients and so forth. Very important to consider that you're not embarrassing the employee in the course of the termination. You're not harming their reputation, even when they may have been a poor performer, or they may have done something to lead to the termination. It's much safer to always try to maintain a professional and above board approach to the termination, because otherwise you're going to see these kinds of claims, and they're becoming easier to be successful on.
We'll go to the next kind of claim that you might see in this situation. And so that's a claim under the Occupational Health and Safety Act. So occupational health and safety legislation in most provinces, not in Nova Scotia, but it requires that employees have harassment or violence in the workplace policies. Where you're seeing these complaints come in is where an employee raises a concern relating to harassment in the workplace and is terminated after raising that concern. And so and just for an example, in New Brunswick's Occupational Health and Safety Act, Section 24 does prohibit reprisals. So it essentially says that no employer or supervisors shall take discriminatory action against an employee because they sought to enforce the Occupational Health and Safety Act or acted in accordance with the Occupational Health and Safety Act. And so what this essentially does is it lets an employee bring a complaint in this example saying, look, I was terminated and the reason was because I tried to enforce my rights to work in a workplace that's free from harassment and violence. Kind of a key thing that's come out of this is employers initially, they would try to argue that, well, the legislation says because, and so that means there has to be a direct or causal, or the only reason for the termination has to have been this complaint. That's not the case. The test is whether or not it was a factor in the termination. So, you know, if you had a poor performing employee who, you know, you were thinking about terminating and then they file a harassment complaint and you say, well, look, this is a straw that broke the camel's back, that's enough to get them within this complaint procedure. Another kind of important thing to come out of this is a decision from the New Brunswick Court of King's Bench, Burke and the Attorney General of New Brunswick. In that case, the court confirmed a decision or upheld a decision of an arbitrator explaining the jurisdiction on these claims. So when you have these complaints come in, the arbitrator, they're not making a decision on whether or not there was harassment. They're not making a decision on the merits of the complaint. They're only focusing on whether or not it was a factor or a reason for dismissal. And so that kind of has big implications. Because it means that somebody who may have brought a frivolous complaint or a complaint that may not be completely made out, or a complaint that, you know, they saw as harassment but didn't actually meet that threshold, may be enough to get them into this kind of category of complaint, provided it was a factor in their termination. This is also kind of significant, this procedure, because the remedies kind of go beyond what you would see in the wrongful dismissal claim we discussed previously, in that the complaint in this case would go before an arbitrator, and they have the ability to reinstate the employee with back pay, and they have the ability to impose an administrative or monetary penalty on the employer. And so in the Burke case, where, you know, the arbitrator discusses jurisdiction, this was a case where reinstatement was kind of the preferred remedy. And what happened there is the employee had raised a complaint of sexual harassment, personal harassment, and poisoned work environment against their supervisor. And the employer kind of cooked up a story about concerning allegations against her husband, but they weren't really ever able to prove it. So they had alleged her husband, there was some ongoing police matter with him, and because of that, they could no longer trust her, and kind of her ability to carry out her duties had been compromised. And so when they ended up in arbitration on this, the employer was really just unable to produce any comprehensive evidence showing that there was a concern and that would affect her ability to do her job. And so the remedy in that case was reinstatement with back pay. And so to kind of take away on these cases, and we'll get into how you can kind of protect yourself a little later, but one of the big things is if you are dealing with a person who you know, has ongoing problems and is involved in one of these harassment or violence in the workplace situations, you really do want to make sure that you document everything and all the evidence that you have that would support a termination, you know, kind of outside of that complaint. I don't know, do you have any thoughts on that one, Alex?
No, but we do have a question down in the chat box just on this topic while we're here.
Yeah.
You want me to field it?
Yeah, go for it.
Sure. So the question that we've been provided is, would completing the investigation of plaintiff's complaint of harassment and finding it to be unfounded reduce the damages if Pat was then terminated for performance concerns? I would say yes. So what you've done by completing the investigation is essentially put an end to that claim that Pat has been dismissed because of the complaint. You've gone through the steps of investigating the complaint. You found it to be unfounded. It's not the complaint now that's triggered the termination. A lot of this is sort of these sections of these statutes are meant to avoid terminations where either the employer doesn't want to deal with the substance of the employee's complaint, or the employer is concerned about what the outcome of an investigation of the complaint would be. So it's sort of, it's to keep employers honest in doing their duty to investigate these kinds of complaints and address these kinds of complaints, and then also not to sort of permit punishment where there is a complaint that had merit. So in that case, if you completed the investigation, then the employees lost sort of their claim or lost any, real hope on their claim that they were dismissed because of the complaint. And so that would reduce the remedies available to the employee and very likely reduce the damages that the employee could receive. Equally, in that sort of wrongful dismissal claim where they're claiming bad faith, if you can show as the employer, hold on a second, we were acting in good faith. We investigated the complaint. We had an outside investigator. They talked to everybody involved. They told us in their report that the complaint was unfounded. Then the employer can point to that and say that, everything we did was in good faith. This had nothing to do with the reasons for termination. And that may reduce damages or completely eliminate that element of the claim.
And I think to kind of add on to that, another reason why it's a good idea to to take these things seriously, even if you do have other concerns about the employee, is even if you don't make the decision to terminate an employee, employees can in certain cases allege that they've been constructively dismissed if there is kind of a toxic work environment or a poisoned work environment or abuse of authority or something like that. And so, in those cases, sometimes employees will bring complaints and then turn around and say, well, look, I've been constructively dismissed. That kind of argument might fly if the employer doesn't take the complaint seriously, doesn't investigate it, doesn't do their due diligence. But if the employer can show that, look, we got a complaint, we were taking steps to address that complaint, it can be used as a defense in the event that the employee comes back and says, well, I've been constructively dismissed. The employer can then go to court or go to the arbitrator, whoever's been appointed, and say, well, the complaint was raised and the person didn't give us a chance to kind of address it before taking this extreme action. And in those cases, if the employer can show that they're acting in good faith, they're taking reasonable steps, and they're kind of upholding their duty, it can be a defense to these constructive dismissal claims. So when you are dealing with a complaint, it's always a good idea to, regardless of the surrounding circumstances, take it seriously, investigate it fully, and don't just kind of go through the motions. Take it seriously and do it well, because it can pay off in the long run.
And just a final thought on that, depending on what the nature of the harassment is, so if it's harassment on a protected characteristic, for example, gender or disability, you as the employer may have a statutory obligation to investigate under human rights legislation. And so having failed to investigate that type of complaint, the employee would have a very easy claim or complaint to the Human Rights Commission in your province, Human Rights Board of Inquiry in your province, that I've been terminated immediately after raising this complaint. There's been no investigation, and that would be a fairly easy human rights complaint to make and to be successful on.
So we'll go into kind of the third type of claim that in our hypothetical the employee could bring, and that's a reprisal or whistleblower complaint under employment standards legislation. So what this is, just to give you an example, under the New Brunswick Employment Standards Act, Section 28 prohibits an employer from terminating employees in a number of circumstances. One is making a complaint under the Employment Standards Act, but kind of the third item that they discuss is giving information or evidence against the employer with respect to a violation of any provincial or federal act or regulation by the employer while carrying on the employer's business. So this is this is kind of a very broad process that allows employees to kind of say, well, look, I was treated differently or I was discriminated against by my employer because I was seeking to comply with any legislation. So this takes it a kind of a step beyond what we discussed in the occupational health and safety sense. These types of complaints, these whistleblower complaints, are not terribly common at this point, but in the past few years, specifically around 2018 is where you see the cases kind of start to come up where employees are alleging these kinds of issues. They have been kind of steadily increasing since then. And so in New Brunswick anyway, there haven't been any cases where this has been used to actually reinstate an employee. There's been a case where an employee was found to have been entitled to reinstatement, but the arbitrator ultimately found that due to the circumstances and kind of what it had led to the complaint, reinstatement wouldn't be appropriate because the relationship had just entirely broken down. But that doesn't mean that it's not coming. And then, like the occupational health and safety context, the remedies available in this case, in addition to reinstatement, are back pay and the potential for an administrative penalty, so a fine against the employer. One interesting thing that I actually found while kind of going through this in the Employment Standards Act is when the Director of Employment Standards is kind of given these broad powers to issue these extraordinary remedies. And Section 65 of the Employment Standards Act actually says that 65 sub 2 says the director is not required to serve notice upon or hear any person before making an order under subsection 1. So that's kind of significant because it means that there is potential for, and you know, this may or may not happen, but there is potential for the director to make a decision, and you basically just be given notice of the decision that was made. Another kind of key feature of these provisions in employment standards legislation is employment standards legislation in New Brunswick and in other jurisdictions as well, basically says that, look, this applies notwithstanding any agreement to the contrary between an employer and an employee. And so we're going to get into the concept of a release here eventually. But what that means is you can't release a claim under this whistleblower section. So, you know, even if you do get a release from an employee, it's not going to necessarily prevent them from bringing one of these types of claims. Alex, I don't know, do you have any thoughts on that?
Yeah, I find this is always tricky because statutory rights you generally can't release. So you know you've settled with the employee, you want them to sign off on a release of all claims. I think you have to get a little bit creative in drafting your release language. You know, you might not be able to have the employee actually release the right to make the complaint, but they could admit in the release that they have no complaint. So I agree I've not been discriminated against, or I agree that I was terminated on a different basis than having made this complaint. So that, you know, theoretically, if they were to try to double dip both your settlement and making that claim, you could point to a document that they've signed where they've agreed that, you know, what they've previously alleged didn't actually happen. You know, I don't know that that's necessarily going to be a slam dunk, but, you know, it's a creative way around sort of some of this, the issue of releasing statutory rights. There's a question down in the down in our question box here. If you keep a daily notebook / log of calls, discussions, etc., can it be relied on as defense support? And that's yes, absolutely. That's a very good practice to keep, but keep in mind, you know, one item, which is that those types of documents would absolutely be subject to disclosure in a lot of these types of proceedings. So we'll stick with civil claims for now. In the courts, you'd be expected to produce all your relevant documents to the plaintiff. That would include anything that you've got internally where you're talking about that plaintiff, the termination of their employment, etc. So what you document may at some point have to be shared with the plaintiff themselves. And most of these other administrative decision makers also have the ability or the power under their statute to order production of documents. So bear in mind that these things may have to be shared with the plaintiff, but equally speaking, they can be very, very helpful evidence. I mean, I think we generally advise that, if you've had a call or a meeting with an employee who, you're considering disciplining or you're considering dismissing, have somebody else in the room with you, have somebody else on the line with you, both take very good notes, save those notes somewhere accessible, date them, sign them, so that you've got sort of a contemporaneous piece of evidence about what went on in that meeting, because you might be litigating, a past discipline issue that could be years in the past by the time you finally get to litigation, and that would be very helpful evidence to have. The other thing that you should think about is creating a paper trail of your decision-making processes. So you're deciding to dismiss an employee. Let's say it's because they're not meeting their sales targets, for example. You might look at the numbers, decide internally in a meeting that it's time to let this person go, issue them the dismissal. This person has a protected characteristic under Human Rights Act. They file a discrimination claim saying, you chose them on the basis of this protected characteristic. Your defense is, no, we did it because their numbers are poor. Here's their numbers compared to our other employees. But you have nothing else besides that. The human rights investigator or the Human Rights Board of Inquiry or the lawyer or advisor to the complainant could point and say, well, so-and-so also had bad numbers. Why didn't you choose them? So you want to make sure that you've got documentation of your decision making. So not only do you have the numbers that you can refer to, but you've got internal communications saying, I think this is unacceptable. This is why we've got to let this person go. You've got notes of the meetings where you've discussed letting the person go and the reasons for it. Think about the paper trail that you would need to defend a potential claim, because you don't want to be left without any evidence, and it's really just, well, you'd have some evidence, but it would just be your word versus their word, which can be difficult, especially at bodies like the Human Rights Commission and employment standards tribunals, which I would say are very employee friendly.
And that's kind of a good point too, when you're looking at, the reasons for termination, especially when there could be allegations of discrimination involved. When you're putting together your termination letter, if you're writing, well, look, we decided to terminate this person because of performance issues, and you have nothing to back that up and end up in front of a Human Rights Commission, that's going to look suspect, right? Because the question is, well, if that's the reason, where's the proof? You're in the position where you have to prove something that you alleged in a termination letter, and you've got nothing to back it up. And I think kind of the flip side of that is sometimes when employers are dealing with difficult situations and maybe issues with employees, and this comes up in the context of harassment all the time, where they might not feel comfortable addressing that with the employee, they'll put in the termination letter, oh, they were terminated because we decided to go in a different direction or something like that, kind of these vague statements. And that can actually cause kind of big problems if you do end up in front of a Human Rights Commission and the person is alleging discrimination, because at that point you're in the position where you have to say, well, no, we actually did have other reasons for terminating them. It was either, they were creating a toxic work environment, they were caught doing something that they weren't supposed to, or that was that you didn't want to discuss with them. And then the commission is in the position of asking the employer, well, if that was the reason, why didn't you say that in the termination letter? And so you've kind of got to argue against yourself at that point. You've said, we've decided to go in a different direction in a written document that's going to be relied on as evidence. And then you're going to the commission and you're saying, well, that wasn't really the reason. We actually had other reasons. And so kind of the big takeaway there is, if, having difficult conversations and raising those difficult topics at the outset can save you a lot of headache down the road. And just to kind of tag on to this question, I think one of the key kind of things here is daily notebooks, the inclusion of the word daily. So you really want contemporaneous notes. You want notes that were taken at the time you had the discussion or as soon after as possible. Because what these are really relied on is, as Alex said, when you're dealing with a claim months or potentially a year or more down the road, it can be very hard to remember what happened, what was discussed, what was said, And the closer to the actual conversation your notes were taken, the more reliable that evidence will be.
And just one more point on something that Chris said in there. What you say in the termination meeting and letter, should be thought about fairly significantly. What if you're going to give a reason for a without cause termination? What purpose is that reason serving? Is it to soften the blow? Is it likely to be accepted by the employee? There's a lot of strategy that goes into what, if anything, you're going to say on a termination without cause. In some instances, it may be better to say nothing and sort of leave multiple positions open to yourself later on. And others, if you think it's going to soften the blow or limit the chance of litigation, it may be worth going the extra mile and explaining, well, this is due to financial difficulty. For example, that one may, in some instances, sort of discourage the employee from making a claim if they understand that, they're really only being let go because the company's not doing well. Especially if you're a small employer that, they may take some sort of pity on. Chris, I'm just looking at our time. We should probably move through our next example fairly quickly.
So kind of the last claim here is human rights. And I think that we've discussed the human rights context kind of at length already. The kind of only piece that I would add here is there is also kind of these reprisal provisions in human rights legislation. So the same way there was an occupational health and safety legislation in the Employment Standards Act, if you take discriminatory action or if you take a reprisal against an employee because they made a human rights complaint, you can also find yourself on the hook for that. The next example, I'll let Alex kind of start with this. It's basically the same example, but in a unionized environment.
Yeah, so we'll try to breeze through this to get to the case law, because the case law will tell you the same thing as these examples. But so here we've got Gail Griever, and Gail Griever is complaining to their manager Lou that their supervisor Ali has harassed them. Same, general setup here. Lou is golf buddies with Ali, so you've got a manager who's buddies with the supervisor, and the complaint is against the supervisor. There's no investigation. It's just dismissed out of hand as being unfounded. And a few weeks later, there's been a termination of employment on the basis of performance reasons, remembering that this is a unionized workplace. The employee is handed a termination letter, and it is seeking the employee sign off on the termination, releasing claims, and acknowledging the sort of veracity of the termination. This is going to open up a whole bucket of worms, because we're talking about a unionized workplace where all the rights of the employee flow through the collective agreement for the most part. So the employee goes to their representative, their shop steward, etc., and has the union file a grievance on their behalf, seeking to be reinstated and seeking back pay for the period that they were out of work. So very classic situation dealing with a termination. As any of you who are unionized on this call know, high standard to establish cause for termination. It can be very difficult to do so. Typically, an arbitrator will substitute a different result, whether it's a suspension if there has been a real disciplinary issue, or a warning, and certainly can reinstate, and it's quite common. Because it is just such a high standard to meet cause for termination, or to establish that there's been a just dismissal. That language kind of will depend on which jurisdiction you're in. So let's go to the next slide there. So not only can that employee who's typically, going to go to grievance arbitration as their first recourse, not only can that employee go to grievance arbitration, but they can also file an Occupational Health and Safety Act complaint. So based on the way that this law has gone, and we're going to get to these leading cases in a moment, but it's not the fact that the unionized employee is stuck with just the recourses that are available under the collective agreement. The law has moved, or has found in most provinces and in most jurisdictions that the employee also still has statutory recourse under employment standards legislation in some instances, especially around dismissals, and then also occupational health and safety and human rights legislation. So that's where we get the third claim, which is a discrimination claim under human rights. So you could be facing essentially the same or very similar claims in 3 different forums from the same employee. And that is, you know, a significant amount of work for the employer to defend all 3 of these claims. Again, with something like an occupational health and safety complaint, something like a human rights complaint, that employee does not need legal representation. It's a very low cost to entry. They simply work with the statutory tribunal. They will investigate it on their own, and so the employee does not generally need to, you know, put much money in or much time in to pursue these complaints against their employer.
So we'll skip ahead a little bit here, just being mindful of time, because I think we've discussed the release quite a bit. And kind of the big thing that we did want to discuss is this topic of concurrent jurisdiction. So when you're dealing with 2 kind of different decision makers who do have authority to make a decision, it is possible, you know, in some cases they may have exclusive jurisdiction, meaning only they can make that decision. And in other cases, they may have concurrent jurisdiction, meaning that there are more than one body that can make that decision. And kind of an issue of this is they can make the decision sometimes at the same time, which, as you can imagine, has kind of broad-reaching consequences. You can get conflicting decisions. You know, again, there's different evidentiary standards that you have to deal with, different timelines, which can be hard to manage, and the different remedies all put a lot of pressure on employers. And this is an area where we've seen some development of the law in the past year or so, specifically in the context of labor arbitrators and human rights commissions. And so this all stems from an old Supreme Court decision called Weber. It's spelled Weber, but pronounced Weber, where the Supreme Court was basically asked to determine a test for figuring out how you deal with these overlapping jurisdictions. And so kind of this evolved into a 2-part test that was kind of described in another Supreme Court case called Morin. And essentially what you're doing is you're looking at the first piece of legislation and you're saying whether that grants exclusive jurisdiction based on the language of that statute. So you read the statute, you say, does this legislation or does the statute say that only this person can make a decision on this thing? And then the second step is to look at the actual dispute in question and say, does it fall within that kind of circle we've drawn? And if it does, then only that person can make the decision. What Weber and what Morin did and what the next kind of decision that we'll talk about is they kind of explained where there can be carve-outs to that jurisdiction for another body to come in and make a decision at the same time. And essentially what they're looking for in those carve-outs is whether there's another piece of legislation that says, well, look, you can also make this decision. And so that kind of ended up in this decision of the Supreme Court in 2021 called Northern Regional Health Authority and Horrocks. And essentially that was a case where there was a grievance, so it was a unionized context, and that had been filed, and the employee was also pursuing a human rights complaint relating to kind of the same set of facts, the same circumstances. And the Supreme Court essentially applied this Weber and Morin test, and they said, well, if you look at labor relations statutes, so the Industrial Relations Act, and other labor relations statutes, it says, well, labor arbitrators have exclusive jurisdiction to decide anything relating to the interpretation or application of a collective agreement. They then looked at the human rights legislation in this case, which was actually in Manitoba, and they said, well, does this provide kind of an exception to that rule, and determined that it did not. And so in that case, they did find that the labor arbitrator had exclusive jurisdiction and was the only body that could make that decision. So then everybody was wondering, well, how does that apply in our province, right? the test is very clear. The application in Manitoba was quite clear, but how does that apply in my province where the legislation might be a little different? And so I'll go through kind of the New Brunswick portion, and Alex, I think, will address the Nova Scotia portion. So in New Brunswick, the issue was actually decided by the New Brunswick Labor and Employment Board in the decision of Robson and University of New Brunswick. And so that case involved an employee who was alleging that they had been discriminated against on the basis of the university's retirement policy, which basically said, you know, when you turn 65, you're required to retire. A grievance was requested, but ultimately not pursued by the union, and the employee went ahead and filed a human rights complaint. And the question there was, okay, well, how does Horrocks apply in New Brunswick? Is this something that the Human Rights Commission of New Brunswick can even hear and decide, or is it something that would have to be dealt with at a grievance arbitration? And what the board decided is that the Human Rights Commission and the labor arbitrator in New Brunswick have concurrent jurisdiction. And they made this decision by looking at section 19 sub 2 sub D of the New Brunswick Human Rights Act, which basically says the commission may dismiss a complaint at any stage in the proceedings if the complaint has already been dealt with in another proceeding. And so the board interpreted that as saying, well, look, this clearly states that the board may, so they have the discretion on whether or not they're going to dismiss a complaint that's been dealt with elsewhere, which would include a grievance arbitration. And then the board went a step further and they said, look, even if we're wrong on that, in this case, the issue in question is whether or not a provision in the collective agreement is discriminatory. And they said that goes to the negotiation of the collective agreement. And the Industrial Relations Act only gives arbitrators exclusive jurisdiction over disputes that arise out of the collective agreement. And so they said, well, look, even if we're wrong on the concurrent jurisdiction, if it relates to the negotiation of a provision in the collective agreement, we're going to take jurisdiction because that's not what's covered in the Industrial Relations Act. So in New Brunswick, employers, particularly in unionized workplaces, are in a position now where there currently is deemed concurrent jurisdiction. And I say currently because this decision is actually, it was supposed to be judicially reviewed in December. It got adjourned until June of this year. And so we'll be monitoring that, and we'll have an update on our website when that decision is released.
So from the Nova Scotia perspective, this has been a hot item. There are two cases, both within the last 6 to 8 months. One of them you may have read about in the news, and this is we'll call it the Carleton decision. So Carleton she's a police officer with the Halifax Regional Police. She made a complaint surrounding the accommodation of her PTSD in the workplace. So she made this complaint in two different ways. One was as a grievance under the collective agreement, and then the other was as a complaint under the Human Rights Act. And so the issue was essentially very similar to the issue in the Horrocks case that the Supreme Court of Canada dealt with a few years ago, except that the legislation in Nova Scotia, the Human Rights Act, has different wording than that in Manitoba. And so the question was, should the complainant be limited to the grievance process? You know, it's assumed that labor arbitrators have exclusive jurisdiction over issues under the collective agreement, and that includes workplace accommodations in the unionized workplace. But is there anything in the Human Rights Act that indicates that the Nova Scotia legislature intended human rights tribunals, so that would be the Nova Scotia Human Rights Commission, Nova Scotia Human Rights Board of Inquiry? Is there anything that indicates in the Human Rights Act that the legislation or that those bodies could also take jurisdiction over the same complaint? And what the court found was that there was essentially an opening for the Human Rights Commission to retain jurisdiction over a complaint, even though it was being pursued in a grievance. So section 29(4) of the Human Rights Act in Nova Scotia says the commission may dismiss a complaint at any time if, and then subsection D, the substance of the complaint has been appropriately dealt with pursuant to another act or proceeding. And so the key word here is that the commission may dismiss. So it's a discretionary decision of the Human Rights Commission as to whether or not it will accept a complaint that's being dealt with in another proceeding. It's not mandatory. So had the legislature intended that the Human Rights Commission not deal with complaints that are already being pursued by grievance, or another statute, for example, labor standards or occupational health and safety, then it would have said must dismiss if it's being pursued in another proceeding. One of the three judges on the Court of Appeal also disagreed, so they dissented from the other two judges on the basis that they didn't think that this exception included grievance arbitrations under a collective agreement. So they made, an argument in their dissent that what it's really referring to is other claims to other statutory administrative decision makers, and a grievance arbitrator isn't a statutory decision maker. They're appointed under the collective agreement, so they're really a private arbitrator. Anyway, that was the dissent in that case. One more case actually just came out last month, so January, I think 16th. This case came out, and this was involving an employee that had made both an accommodation claim in the form of a grievance, as well as also a workers' compensation claim about accommodation. And here the issue was, generally speaking, workplace injuries are covered by workers' compensation legislation, and it is meant to replace any other method of seeking sort of recourse for your injury in the workplace. However, it's possible that collective agreements provide better rights for accommodation than the Workers' Compensation Act. And the court, in determining whether or not the Workers' Compensation Act foreclosed any type of claim under a collective agreement or any type of grievance, found that it did not. The Workers' Compensation Act replaces a worker's ability to sue in civil court. It does not replace a worker's ability to pursue other statutory claims per se, or claims under a collective agreement. So, the historical trade-off for workers' compensation is that the legislation was put in place to avoid employees suing their employers in court for injuries sustained in the course of employment. But that was the extent of sort of what's been replaced by the Workers' Compensation Act, still open to employees to pursue grievances and potentially other statutory claims. It'll be interesting to see if that goes to the Court of Appeal. Again, that's a very recent decision, but in any event, a very hot topic right now, and difficult for employers who are facing a multiplicity of proceedings now.
And so, just mindful that we're at 12:01 here, we just kind of put together, as I think has probably been demonstrated by this point, as Alex said, managing these multiple proceedings is very difficult, puts a lot of pressure on employees, and it can cost a lot of money. So if you want to kind of set yourself up, the issue with this is the legislature has basically put all these different options out there to employees and has handed this off to employers and said, you figure out how to deal with it. There's not much there's not much in terms of outs or defenses or exceptions that they've provided. They've essentially said to employers, look, you figure it out. And so we've just got a quick list here of some kind of tactics that you can do to kind of increase your success, limit the risks associated with these proceedings. So the first is make sure you've got consistent responses across proceedings. This is going to limit the risk of you getting conflicting decisions that you'll then have to address down the road. Consider in what order you want to respond to the claims. So having certain claims dismissed initially may be more beneficial. If you're dealing with a reinstatement claim, you might want that kicked before you end up in court seeking damages, right? Because the remedy is obviously a lot more severe. Look for early resolution procedures. Mediation is always a good one. Settlement, that kind of thing. Look for simplified procedures, so summary judgment to kind of speed up certain processes. And then I think a big one is going to be to seek adjournments or a stay of proceedings pending outcomes of the others. That, in my opinion, is kind of your biggest one here when you're faced with these, because it does kind of eliminate that fighting a battle on multiple fronts, and it does avoid potentially conflicting decisions, right? Because if you get a decision in one instance that makes another moot, then you can raise that as a bar to the other claim. And then, I mean, the other we've kind of discussed already, and I won't belabor those anymore. So we'd like to, I guess we're kind of out of time for questions, but we dealt with them as they came up in the presentation. We'd like to thank everybody for taking the time to join us on this presentation and for kind of going through this journey with us. We understand it's kind of a lot to process, and there's a lot of different things to think about, but thank you for joining us. And Alex, I don't know, do you have any closing comments?
No, I think we've covered sort of the strategy. I think you want to fight one of the battles if you have multiple battles, and as Chris said, try to stay the other proceedings until you get a decision. In particular, you want to get the favorable decision in one, but then you can refer the decision maker of the other complaints to. So you're going to stand up and say, we've already won this complaint in one forum. And here's the reasons, and that would be very dissuasive from that person continuing to adjudicate that claim. So try to only fight one, try to delay the others, and obviously fight it well so that you get a decision that's helpful to you. Thank you very much for your attention today.